Good morning. Test. Is this working? There it goes. Good morning. For those I don't know, I know most folks, but I see a few unfamiliar faces. I'm Doug Reeder. I'm the chairman and one of the founders here at Sterling Seacrest. We very much appreciate you taking the time out of your day to make your way here. We know that's not always easy in Atlanta traffic. We had 285 closed down last night and kind of had a crazy situation out here, so we appreciate everybody making the effort. For those who don't know us, we're a multidisciplinary commercial insurance agency with deep industry verticals in healthcare, construction, real estate and hospitality, transportation, logistics, nonprofit, and private client risk, which means we'll help you with your personal risk management and insurance coverage. We uncover a lot of holes in those when we're called upon to do that from time to time. So please, if you haven't done that in a while, let us know. We also do a lot of work in the benefits arena, helping companies maneuver health insurance, long and short-term disability programs. We're very pleased to have folks from HudsonParrottWalker here this morning. I've seen this program once or twice before in other venues and found it to be really a neat way to convey some of the minutia behind the coverage forms and it gives a realistic look at how your insurance is going to work or not work when you get into disputes. So we're really pleased to have Kevin Hudson, Tony Lehman, and Chad Hayes from HudsonParrottWalker. We have a number of common clients with these folks. Know their reputation and their trial experience is superior in the construction arena. If you have situations that you help with, whether they be reviewing a contract or preparing for a claim or hopefully not, but going to trial someday. These folks really know their stuff and work with a lot of construction companies around the country and have a proven track record that they can show you. They're also panel counsel for a number of insurance carriers who provide general liability in the marketplace. So it's possible that they would bubble up to you in another way through a policy that you've purchased from a carrier. So we're very pleased to have these guys. Let's see. They're going to be holding a mock trial for us today, and it involves an insurance company's denial of a general contractor's claim for project damage caused by a sub. So this is an area fraught with probably misperceptions about what the policy does or does not do. So I think this is going to be a really cool venue to unlock some of those mysteries. So with that, please join me in welcoming the folks from HudsonParrottWalker.
Thank you, Doug. I'm Kevin Hudson. Good morning. Hope everyone's getting ready for happy holidays. I think the great news for you guys this early in the morning is that this is not going to be that PowerPoint presentation where somebody just stands up and reads from the slides and you just kind of follow along. Instead, this is actually a case that I handled some years ago that we have adapted for purposes of a mock trial presentation. And I think the significance about it is really what our firm endeavors to do. We are a primarily construction-based law firm. Our work is largely on behalf of general contractors, but we do insurance defense as well. I don't think you can do construction law without knowing a great deal about insurance, candidly, because you guys are trying to minimize your risk, and that's really what this case is about. It's about what is the risk associated with defective work by a subcontractor, what's covered and what's not. So I'm going to start by introducing my partners, Chad Hayes and Tony Lehman. They are going to present the case. I get to be the witness, which is always interesting. And I also get to facilitate the fact pattern. So what's your job? Your job is to be the jury. So at the end of this, even though we think this is probably a judge-based decision, at the end of this, we're going to ask for a show of hands. There are different elements of damage that are sought in this case. And so you may conclude that the contractor is entitled to no damages or some of those damages. And you can kind of see that through the evidence. The other thing that I think is worth paying attention to is how this case developed, because it didn't just happen. The contractor involved our firm at an early stage. There were a number of steps that happened before you see the insurance company getting involved in the case. All of those steps matter, because the number one defense by insurance companies, and you're going to hear it today, is you didn't give notice or you failed to meet some type of barrier to entry that facilitates coverage in the policy. All those things are important for you to understand, and obviously Doug and his team are experts in that, as are we. Any questions before I start with the fact pattern? Excellent.
Okay. That's why.
Okay, so what this case is about is it's about an electrical subcontractor who did work in connection with a Walmart. And that work consisted of taking from an outside transformer wiring underneath. So the wiring comes from this outside transformer into this main, comes underneath to this interior panel here. The interior panel is provided by Walmart itself. By virtue, at least as the contractor contends, of the fact that the electrical sub short wired this, the only way to install it was underneath. There was not sufficient wiring that was pulled to come into the top of the panel. In addition to that, instead of attaching it to the 1600 amp breaker, which is what was required by the specifications, it was attached to the 800 emergency breaker. The result of this failure to follow specifications, inadequate wiring, is that this panel is completely blown out and the Walmart loses power and is shut down. Anybody who's experienced an owner who has its business shut down, and I hope none of you have, appreciates the exigent circumstances that the contractor found itself in, where the contractor is essentially saying to the sub, you got to fix this problem, but on top of that, you got other damages associated with that. So this piece of property, again, by Walmart, the solution, and this is an interesting aspect of the case, that had to happen is a completely different set of wiring. You could no longer you couldn't use the underground wiring anymore. You had to wire it over the top. There were costs associated with that. You had to depower the entire operation, and obviously the contractor incurred general conditions along the way for that. So those are the facts, and with that, I'm going to turn it over to Mr. Hayes. And I occupy the role of the insurance adjuster who has been presented this claim.
Morning. I'm Chad Hayes, counsel for Neighborhood Insurance. For our first witness, we would like to call Kevin Upsell. Mr. Upsell, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Upsell, if you could please give us your full name and position with Neighborhood Insurance.
So I am an adjuster with Neighborhood Insurance. Full name is Kevin Upsell, and my job is to evaluate claims, make decisions about claims.
And how many years experience have you been doing that with Neighborhood Insurance?
Gosh, given the thousands of claims I feel like I've dealt with, it feels like my whole life, but I think I've been doing this for about 15 years.
And you're familiar with the terms and conditions of the standard CGL policy that's issued by Neighborhood Insurance?
Intimately familiar with those terms and conditions.
Very familiar with the exclusions in there that allow for Neighborhood Insurance to determine whether there is or is not coverage.
Live by those exclusions, yes.
Okay. If you please look at exhibit number 1, this is, can you tell me what this is?
Okay, this is a letter that is sent from the general contractor to our insured miswired electric, and it is copied to us.
And it's dated December 10th, 2012, correct?
Correct.
And in this letter, what was the general contractor telling your insured, Miss Wired Electric? What prompted this letter?
So the general contractor is explaining that it has a contention that our insured has done defective work and caused damages in the form of causing a Walmart to lose power associated with the electrical work provided by our insured.
And the general contractor is looking for your insured to make them whole for the damage that has been caused, correct?
Correct.
And that's under the terms of their contract and the indemnity in their contract, correct?
Yes, that's what they say.
Okay. And you, as neighborhood insurance, were not specifically addressed, but were just added as a CC on this letter, correct?
That's my understanding, yes.
Okay. Can you tell me what exhibit number 2 represents?
This is my letter sent back to the general contractor acknowledging that I got the December 10 letter and that we are investigating the matter under a reservation of rights.
And what does it mean that you are investigating the matter under a reservation of rights?
All right, so we haven't made any decision one way or the other about whether there's coverage. But in order for us to make a decision about whether there's coverage, we have to conduct an investigation. And we want to be able to conduct that investigation without waiving our position about whether there is or is not coverage.
Okay. And you also said in your letter, we are unable to accept your tender at this time. What's the reason that you are unable to accept their tender? What does that mean?
It's the same as whether there's insurance or not. So in the December 10 letter, what the contractor is asking for is for our insured to take over the defense and to indemnify them in connection with Walmart's claim. So they want them to both handle all the legal action as well as pay Walmart to the extent something's supposed to be paid. When that's tendered, that means that it's kind of like a lateral in football. Instead of them carrying the ball as a general contractor, they try to lateral the ball to the sub. Well, the sub tries to lateral the ball to us because we're an insurance company and we're providing that same defense and indemnity only through an outside policy. That's what an insurance policy is. So in effect, what I'm saying there is to the general contractor is we ain't doing anything yet because we've got to go do an investigation, and until we do an investigation, there's no responsibility.
You also say in your letter, it does not appear that your insured is an additional named insured on the policy. What is an additional named insured and why is that significant?
Okay, if the general contractor, in the course of negotiating with the subcontractor, had a provision and an endorsement that made it an additional named insured, then the general contractor would have the direct ability to come to us as the insurance company, just as the subcontractor could come to us directly as the insurance company. But because they're not listed as an additional named insured, they don't have that. So the only way that we have any obligation is going to be kind of a flow through from the subcontractor. We owed no direct obligation to this general contractor.
So what that means is this letter that was submitted on December 10th is not a direct claim by the general contractor against the insurance policy.
In our opinion, that's exactly what it means.
Okay. And then you requested some additional information from the general contractor, correct?
That's what we're going to have to do our investigation, including all this engineer of record inspection as to what caused this problem. I mean, just because somebody says, hey, this big catastrophe happens doesn't mean it's insured.
Okay. And once you received that information and conducted your investigation, you ultimately denied Ms. Wired's claim in April of 2013, correct?
That's correct.
Okay. And the basis of your denial was based on exclusions in the policy relating to the subcontractors, what we would call the your work exclusion, correct?
That's right. We're not in the business of providing insurance for bad work by a subcontractor.
Right. So after that denial and after you completed your investigation, you never heard anything more from Miss Wired Electric, correct?
That's right.
It was radio silent the entire time.
True.
The first thing you heard of any kind of a lawsuit against Miss Wired Electric was when you, as the insurance company, got sued to collect on a default judgment that had been entered against Miswired Electric in favor of Build It Right, the general contractor in this lawsuit, correct?
Correct.
And this action is actually a garnishment proceeding where they're seeking to collect against Neighborhood Insurance on that default judgment entered against your insured, correct?
That's right.
Okay. Did Miswired Electric provide you notice of the lawsuit that was filed against them?
Not of the lawsuit.
Okay. And in exhibit number 3 here, we've got an excerpt from your policy, correct?
Yes.
And the language that's quoted there, can you read that to us?
This policy requires notice as soon as possible and for the insured to immediately send Neighborhood Insurance copies of any demands, notices, summons, or legal papers.
Which you already testified Miswired did not do before.
Not for the lawsuit.
Okay. And so you had no opportunity to defend Miswired in the lawsuit because you didn't know anything about it, correct?
That's true.
And what is the
Although
consequence?
we'd already denied coverage.
True. But had you known about the lawsuit, you might have defended it, correct?
I don't think so. We denied coverage. So our position was there was no coverage, but we would have at least known about the lawsuit, which we're entitled to know about under our policy.
And in any event, what's the consequence of not providing notice of the lawsuit under the policy?
No coverage.
Okay. So in any event, failure to provide notice was no coverage, and there was still no coverage under various exclusions in the policy, correct?
Right. We'd already determined there was no coverage, and this is another reason there's no coverage.
So one of the reasons that you gave for no coverage was related to the definition of property damage in the policy, correct?
Prior to the lawsuit, yes. Our position is that defective work, where you're just replacing the defective work, is not property damage.
Okay. And in this case, for what Build It Right seeks to recover, was there any damage to Build It Right's property?
No.
Okay. And when we talk about property damage, what's the definition in the policy? We've got it here in Exhibit 4. If you could read it to us, please.
All right. Property damage is defined as physical injury to tangible property, including all resulting loss of that property or loss of use of tangible property that is not physically used.
Okay. Can you give us a layman's explanation of what that means and not insurance speak?
Well, I think a good example would be that if our electrical sub-insured had installed a defective light switch and it caused a fire and the fire burned the room, then the area burned by the defective work is property damage, and that's the kind of thing that we cover.
And here, Build It Right was seeking to recover economic loss that it suffered on the project and not actual damage to its property, correct?
That was part of what they were seeking to recover, sure.
Okay. And it was your position that that was not covered, that economic loss was not covered under the policy, correct?
Our position was all of their claims weren't covered, including the economic loss of Walmart or the general conditions they incurred or the engineer they incurred. All that stuff was just related to defective work by our insured, which was not covered.
Okay. And then lastly, we've got the your work exclusion, correct?
Yeah.
That's shown here on Exhibit 5. If you could please summarize what the your work exclusion is.
So that's saying that if your work is defective and damaged and your work has to be replaced, then that's not going to be covered. And what essentially the difference is that if you have defective construction that causes damage to other property, that's one thing. But if you have defective construction and you're just seeking to recover for the defective construction, we don't insure for that.
Okay. And it was Neighborhood's position that what Build It Right sought to recover in this case was for damage to the work of Miswired alone, correct?
Right, yeah. All that wiring that they're claiming was flawed is absolutely the work of the insured subcontractor.
And all those damages would be outside of the policy and uninsured.
True.
I rest.
Good morning, Mr. Upsell. My name's Tony Lehman. I'm here representing Build It Right. I'm going to have a seat because I have some notes here that I need to use to ask you some questions because of kind of wanted to cover your testimony in full. Let's talk first about what we can agree upon here.
Okay.
Would you agree that Ms. Wiard's bad work on the Walmart project caused the power outage on November 16, 2012?
My understanding, yes.
You would also agree that this outage shut the Walmart down for several hours, correct?
Got a nice photo of it, yep.
Exactly. You would also agree, based on your investigation of the claim, that Ms. Wiard's work was performed so badly that the wiring was installed so improperly that its work had to be abandoned into place, correct?
Yeah, no question that the work was bad and abandoned.
You would also agree, Mr. Upsell, that this panel that Walmart provided was destroyed by the improper work of Ms. Wiard, correct?
Correct.
And this panel was not within Ms. Wiard's scope of work on this project, correct?
The panel wasn't, the connection to the panel was.
But the panel itself was not.
True.
Okay, let's look at your Exhibit 1 that we've talked about. Now, you received this letter from Build It Right in December of 2012, correct?
Yes, sir.
And this letter describes the outage at the Walmart that shut it down?
It does.
And you'd agree that this letter also states the panel was destroyed by Ms. Wiard's faulty work, correct?
It does.
Okay. Let's look at your response to that letter, which came 3 days later. You admit you wrote this letter, correct?
Yes, sir.
And your letter actually calls this notice of this matter having been given to Neighborhood Insurance, correct?
Correct.
And after receiving this letter, you performed a full investigation of the claim, correct?
Yes.
And your full investigation involved whether there was coverage or not, correct?
It did.
Now, I note we didn't see the denial letter that you wrote in your direct examination. Do you recognize this as being the denial letter that you wrote in this matter?
I do.
And this is Exhibit 6. And this was dated April 19th, 2013, correct?
Yes,
And this was sent to Miss Wired Electric by you, correct?
it was.
And if we just look at your basis for denial, your basis for denial of this claim is solely based upon the your work exception, your work exclusion within the policy, correct?
Yes, in the first page it says, we've now completed our investigation of the facts and circumstances surrounding the claim of the general contractor regarding your alleged defective work at Walmart. Regretfully determined there is no coverage to the loss. And then I refer to a whole lot of policy provisions, but all of them lead to the fact that at bottom, this is trying to present a claim for defective work by Miswired Electric, and we don't cover that.
And this was the end of your investigation regarding this claim, correct?
Till you guys garnished, yep.
And there isn't any mention of a lack of notice in this letter, is there?
No, sir.
There's not any mention of the idea that Build It Right didn't have physical property that was damaged, is there?
No, sir.
You also sent a denial letter on that same day to Build It Right, didn't you?
Yes.
And that letter also provides that the sole reason for correction is your work, that you denied because of the your work exception, correct?
Correct.
Okay, I want to go back to this slide here now. Now, as an adjuster, you are familiar with the Georgia law regarding the issue of determining coverage for a loss, correct?
In general terms, yes, sir.
Okay, and you're familiar generally with this case of Hoover v. Maxim Indemnity Company that was decided in 2012, aren't you?
Yes, sir.
And this was decided before you wrote your letter in 2013 denying coverage.
It was.
And let me draw your attention to this second paragraph here, where it states, a reservation of rights does not exist so that an insurer who has denied coverage may continue to investigate to come up with additional reasons on which the denial could be based if challenged. Do you see that language?
Yes, sir, I did.
And that language means that when you deny coverage, the reasons you give in your denial are the reasons you have to rely upon in any further lawsuit, correct?
I think you'd have to ask a lawyer then.
Well, you're familiar with this provision though, correct?
I know what it says, what it means. Probably need a lawyer.
Okay, and so your letter didn't mention, it only mentioned your work though, as we've established.
Oh yeah, we agree.
Correct.
Whether I get a do-over or not, you need to talk to counsel.
We can talk about that later. Let's talk about this damage to other property. If we look at this letter here, we can see that this work, the language here talks about the work that had to be fixed on the project. Do you see that?
Yes.
Okay.
This is back to the, yeah, this is saying that these are the contentions by the general contractor of the areas of the claim. Is that the question?
Correct.
Yeah, it is.
Now, Miss Wired, as we've talked about, did not install this interior switch gear, correct?
Right, that's the Walmart supplied piece of property we talked about.
Right, and that property was damaged, wasn't it?
Yes,
Absolutely destroyed, correct?
by the defective work of Miss Wired, yes.
And Build It Right had to pay for a new switch gear to replace the one damaged by Miss Wired, correct?
That's my understanding, yes.
And Build It Right also had to perform other work, new work, to provide the system that the owner paid for, as it says here in Part 3, correct?
Yeah, it had to, I mean, you can't turn the switch on without wiring it, so they had to basically redo the wiring that was improper by Miss Wired.
And also, Build It Right suffered other damages, such as paying an engineer to determine whether there were any other problems in the system before they could repower the system, correct?
I had other claims for those types of damages, yes.
Okay. Now, this is the policy language that you are relying upon regarding property damage, right?
Yes, sir.
And your argument today is that Build It Right didn't suffer proper damage to its own property, correct?
Yes, sir, we make that argument.
Did Walmart's property suffer damage?
Allegedly, yes.
Was the building itself damaged by having to perform the work to make up for Miss Wired's faulty damage? Some building restoration had to occur to be able to wire the panel properly?
Yeah, you did have to go over the top, so you did have to deal with aspects of the existing structure and the panel that we talked about.
And you'd agree that your denial letter for coverage did not mention property damage, correct?
That's true.
And we can see here again, we've looked at this before, the only thing you're relying upon is your work exclusion, correct?
Correct.
And again, same thing in the letter that you wrote to Build It Right, only the your work exclusion, correct?
Correct.
Let's talk about that your work exclusion now. This is your one stated reason for denying coverage, correct?
Yes.
Did Miss Wired's scope of work under its subcontract with Build It Right include the installation of the main distribution panel?
The interior panel?
Correct.
It did not.
Did Miss Wired's scope of work under its subcontract include the replacement of the main distribution panel?
It did not.
Now, the installation of overhead wire and conduit also wasn't in Miss Wired's original scope of work, was it?
No, it was underground wiring.
And it was also not within Miss Wired's scope of work to have to depower the building to check for other deficiencies in the work, correct?
Correct.
And it wasn't within Miss Wired's scope of work to have Build It Right come back out there to oversee this correction work, right?
Correct.
Okay. So let's look at this chart here. Have you seen this diagram before, sir?
I think so. The blue are intended to be the exterior walls. Is that what that is?
That's right. That's correct. That's the exterior walls.
So this, let's make sure I understand this. The black is showing how Miss Wire did it originally going underneath, and the red is showing it going over the top. Is that what that's intended to show?
That is exactly what is intended to show. Thank you for pointing that out.
Okay.
So let's look at this costs that are listed here. Let's start at the top of this slide, where we have the cost to run completely different wiring above ground and accompanying penetrations that cost nearly $40,000. Now, Miss Wired was paid for its original underground work, wasn't it?
Yes, sir.
And you agreed earlier that Miss Wired's work was performed so incorrectly it had to be abandoned in place, correct?
I did say that, yes.
In your experience, it would be more costly to dig up that work under the slab and of that building and replace it in place rather than performing this work over the top of the walls and going around the outs instead of going underneath. It was cheaper and easier to go over the top of the building, correct?
Correct.
And running this wire above ground was outside Miss Wired's scope of work, right?
Well, they had to run the wiring somehow. So you've got bad work to begin with. You got to replace the bad work. So it wasn't intended to be over the top to begin with, but they do that to account for the bad work to begin with. So I think that's wiring's wiring at the end of the day, in our view.
Fair enough. Fair enough. Miss Wired wasn't required to depower the building, though, was it?
That wasn't the expectation that you're going to depower the building once you complete the electrical work.
And I've beat on this a few times, but again, this switch, this yellow box here, was never a part of Miss Wired's work, was it?
We agree with that.
And the same goes for Build It Right having to oversee the work to fix the work that had been performed by Miss Wired and to do this other work.
Right.
I have no further questions at this time.
Okay, thank you. Okay, so before we delve into questions that may come up about how this went and your thoughts on it, let me just see, by reference to the damages, a show of hands on who would vote for the general contractor. On the Walmart switch replacement, who believes the general contractor is entitled to be paid for that, given what you've heard so far? Okay, majority of the room. On the cost to run the wiring above ground as opposed to below ground, who thinks the general contractor is entitled to recover that?
Are you saying recover from the sub or from the insurance?
Insurance. This is all insurance. Because they got a default judgment against the sub. So if the sub had any money, I don't think they'd be garnishing the insurance company. So this is all insurance related. So from the insurance company, who thinks they've proven their right to recover for that? All right? Not so many hands. Who thinks the consultants for depowering the building is recoverable? Okay, a few more hands. And the general contractor's extended general conditions for being out there, who thinks those are recoverable? Okay, a few more hands. In actuality, that's exactly how the court ruled. All of these damages were awarded back to the general contractor. These damages were not. Now, at the time the matter was argued, however, the concept of rip-tear coverage really wasn't as perfected as it is today. Do you guys know what rip-tear coverage is? Basically, rip-tear coverage is an extension of property damage coverage that says that if you have to, in order to correct the defective work, if you have to go in and destroy or rip and tear property around that, like ripping off all the stucco to get to what's behind it and then replacing that stucco, that's an example of ripping off the stucco to get to the defective mesh behind it, all that's recoverable. Interesting question, because given that the only way to deal with this underground would be you'd have to completely rip out all that underground conduit, and the cost of what that would look like, it'd be an interesting argument if it came up again, because that all that rip tear coverage, that argument that you could make, is mitigated by coming over the top, because it obviously would be, you know, 6 figures plus if you're going to start digging all that up. I think the other issues that are important to consider are, at least from general contractor's perspective, the fact that was the notice sufficient or not. That was a huge argument in the case, and it was made easier by virtue of the admission by, in this case, me, as Kevin Upsell, of the fact that there was a notice. And I think the court rightly said, well, once you say there's notice and once you deny coverage, you don't get another denial of coverage. It doesn't really matter. So the second notice of the lawsuit ultimately didn't matter. If you're, it probably would have been better practice to give that notice in hindsight. Go ahead and give it of the lawsuit, because you'd have avoided that argument. I don't think it would have made much of a difference in the underlying lawsuit because liability was clear, but it would have been probably something in hindsight that we would have done differently, but didn't matter in this case. The last thing that we want to cover, obviously, is that as you get these insurance letters, what they say matters a great deal. And Hoover is an example of that, because they didn't get into it nearly to the level we did in the garnishment trial. But in the garnishment trial, all of a sudden, there were like 4 or 5 heavy vetted insurance coverage lawyer defenses, none of which appear in that letter, right? Because once, and we don't do defensive coverage, but we deal with it because on behalf of our clients, we try to gain coverage. Once an insurance coverage lawyer gets involved, they're going to throw it all at it. I mean, that's what they do. They sit around evaluating the exceptions, the exclusions at a very deep level, and they did in this case. So try to make a whole bunch of arguments that were not really presented this morning because it's outside, but I just want you to be aware of that because the nature of that letter was critical. The timing of it was all critical. What questions can we answer for you guys? Yes, sir, in the back.
Yeah, well, we focus a lot on just giving that one reason for a declination, right? And in a lot of declination letters, they'll say this is our main one, but there may be others that contribute to that. How do you, in this case, if that was in that letter, approach that?
Hoover doesn't permit that. So you can't, they tried to make that argument in this case. They tried to say that this was but one of a litany. And so Hoover says that's not correct. You have to state your position as the carrier because all things being equal, what the law says is that coverage is presumed. So the burden is on the company to say that there isn't coverage. And so because of that strict burden, you can't get away with the catch-all. You're going to have to lay them all out. Yes, sir.
In the beginning, you talked about the contractor was an additional named insured. We require additional insured. I understood that named insured puts you in line for having to pay for a policy if the sub defaults on pay. But if you're additional insured, doesn't that still give you access direct to the policy?
Doug can probably answer this more, but in my experience, it doesn't. What it does is it gives you a right to have communications with them. But when it comes to who has the direct ability to enforce it, and so if you're going to present a claim for bad faith, for example, in order to present a claim for bad faith, you have to be an additional named insured. You have to have a direct relationship with the carrier. If you don't have a direct relationship with the carrier, then in my experience, they say just because you're an additional insured, that means that you're like a third-party beneficiary. You get the benefit of this policy, but you can't enforce it. That's the position they take. But you may have more guidance.
Well, on our side of the fence, you're either a named insured or an additional insured. So when you get into saying additional named insured, you're kind of putting two concepts together. The theory is you have all the rights and benefits of the policy. I think you're coming at it from a practical standpoint. And
I'm just telling you what the carriers write back to me. Every time I've tried to tell them
Well, I was in the letter.
that, I mean, I've never had, right, that letter was, I mean, we changed the actual names, but the letter actually was written by an insurance rep. So that they take the position every single time that I've ever dealt with them that if you're an additional insured, you have certainly a right to recover under the policy, but no right to enforce anything directly against them. That's their position.
But if you're saying,
But I mean, the policy.
I know.
Yeah.
But if you think
but if you're a named insurer, is that?
I mean, we get
is that the
defenses
difference we're making?
from subcontractors, carriers all the time.
I think the solution to all this is probably something that I question whether you obtain, which did you ever get the endorsement?
Absolutely.
Okay.
Always require the endorsement.
Okay, good.
I know.
Well, then you're ahead of the game because if you don't get the endorsement, it will never exist. I'm telling you right now, if you, in the absence of the endorsement, that and you try and enforce it, they'll be like, "What endorsement?"
I've trained me.
Yeah. Well, I don't know that I trained him, but yes, good. As long as you got the endorsement, that's going to help you a lot. I mean, at the end of the day, you certainly have power if you're an additional insured. I take your point that if they don't pay the premium, then it's on you. Although in workers' comp, that's true anyway. I mean, I had that case where the sub didn't pay its workers' comp, and all of a sudden the workers' comp bar said, "Hey, this is all on you, general
Department of
contractor."
Labor has a lot of
Oh yeah,
effect on that, and we face that.
yeah. I mean, then
But on a general liability claim or on property damage, I thought additional insured gave me authority.
Well, as long as your contract does the right risk transfer and you have the right endorsement, to his point, we get defended all the time. I mean, when we push down risk transfer to subcontractors, I mean our GCs, our prime contractors. Does it get contested from time to time? Absolutely. But I mean, I think your example, they're saying there was no coverage. I don't know if I'd overstate that comment in terms of their analysis in this particular case. You know what I mean? I mean, they were basically saying, well, you're not a named insured on this policy, I think is what they meant to say. But it was surprising that they didn't say if there was an additional insured endorsement, they acknowledged that, because I mean, we always would have an additional insured endorsement intended to trigger the indemnity, the risk transfer. And I'm not clear on if that exists.
yeah, where I see it come up the most is and it's not that bad faith claims are all that common. They're not. But the bad faith statute is really about the only leverage you have to getting some insurance companies to move forward. If you don't, and in order to allege bad faith, there are a lot of barriers to do that. It has to be done correctly. It has to show that they didn't conduct a fair, independent third-party investigation. There's a lot of things that go into it. But assuming you met all those barriers of entry, the problem that I've seen with additional insured is just what I've said, which is that they say you can't assert bad faith because you're not a direct beneficiary under the policy, and bad faith only extends to direct beneficiaries. You're an indirect beneficiary. Whether that's been litigated is not something I've seen. I mean, it generally never goes that far, because
Right.
what inevitably happens is you're going to get to some kind of brokered resolution. And it's a lot of just huffing and puffing if you're talking about bad faith. Because in the history of my 30 years almost of doing this, I can count exactly one time when I succeeded on bad faith going to a jury trial, and most people would tell you that's a unicorn. So it's rare that you see it go that far.
One of the things I would want to emphasize about this is that the cost of doing that rework, because this is commonly misunderstood by upstream contractors, that is covered, and it's not going to ever be covered. However, if you buy a performance bond on the downstream party, that is covered.
In Walmart work, usually that's a requirement anyway for having the MEP subs.
Correct.
Moreover, I mean, if you had a broad indemnity form, I mean, the other stuff could potentially be covered too, right? Because that's the cost of correcting everything.
Well, the broad indemnity form is going to extend to the sub, but it isn't going to extend to the carrier. The carrier's indemnity is going to be limited by its policy terms back to the sub.
No, but I mean a bond form. If I have, if build it right.
A broad
indemnity
yes.
form from the sub.
Yeah.
Theoretically, they could have covered all that.
Under a surety, yeah.
Right. Under a surety.
Yeah. It's not an insurance carrier.
But from a strategy standpoint, though, if you had that circumstance, you'd still pursue both, probably, right? Because you want to get at least.
Yeah, that's a good point. Is that even if you do have a bond, you still need to pursue both. You still need to go after the bond and the insurance. Although the insurance carrier is going to say that the bond is primary, which it is.
Except their client could lose their source of business and try to protect their client from going out of business because they're no longer bondable. It's a circumstance I'm dealing with, right?
And, to be honest, the bond concept, and I'm sure you guys have seen this, I've seen it where they say, okay, you got to have a bond, and then they start the construction, and they're like, where's the bond? and they get further down the road and the schedule obligates them to get this guy with the bond and he doesn't have the bond, or for whatever reason he starts coming up with stuff. So I mean, bonds are not, if you have that much time and luxury to get the bonds and get it all ship shape, then it works just fine. But there are issues with trying to bond people, and then there's bonding capacity with the quantity of work that's out there and the stretching of resources of subs. I mean, could be an issue. So got to pay attention to all of it, I guess is what I'm saying. You can't just walk out here thinking that a bond will solve all the issues. I mean, they all have to have
your
insurance.
schedule. Be clear on that,
Collecting on
right?
it.
Well, you
Collecting
can
on it.
collect on them, but it will not save your schedule. But you will get indemnified if you have the right form and a real carrier on it. You'll get indemnified.
Not that they won't fight you anyway.
Correct. I am not a...
It's amazing the difference with the surety though when you develop direct contact, not just sending them letters, but if I call and talk to the surety, and they know that we're serious about making a claim against the bond, they'll put leverage on the sub with more than I can do.
One of the big points that you made was about the notices, and we remind clients of this every time we come out and present coverage. We've got reminders in our proposal form that says, remember to notify us if any of these many different things happen. Can you speak to the legal, because it's changed. I mean, there was a court ruling several years ago that it used to be if you didn't compromise the carrier's position by a late notice, they would still defend. And there was a court ruling that said, "Now we're interpreting this as just what it says. You notify us, or you don't have coverage." And we've had a few circumstances over the years where somebody, was contacted about something, and in the case that I'm thinking of, it was a labor dispute, a payroll dispute, where somebody said, well, I worked on this job and you had me classified as an apprentice and I was really a journeyman, that's $20 an hour difference. And the client didn't think about it and just wrote a letter back saying, no, that's not true. And, blah, blah, blah. And there was an exchange, 2 or 3 exchanges of letters before it escalated to all of a sudden they're hearing from the labor department. And my fear on something like that is, you're not sensitive to the requirement that you notify the carrier, and we lose coverage because you've essentially started a process and you haven't really included them. And so,
like all notice arguments, the reason for lawyer jokes is because we just spend our lives looking for exceptions to what seems to be things that are black and white, right? So, this is no different than a sub trying to make an argument to a GC saying that, well, we were talking on the job site about this change order for weeks. You know all about it, even though I didn't give you notice. Therefore, you're on the hook for the change order. I mean, it's the same kind of arguments that have been made in the past about, insurance. That, well, you knew, I talked to this, I sent you this. So I guess the question that I would put to you guys is, which would you rather have? I mean, a clean cut, easy, check the box, notice was done, or a debate about whether a text message that vaguely got to it satisfied it. And not only would I recommend that you want to understand those notices, the particularities of those notices actually matter, because you may have to require or may provide multiple notices. The other thing that's happened, and I see this in construction contracts all the time, but it's true in insurance contracts too, is that they've gotten much smarter about how they write the notice language. So now they write it as a condition precedent to something. But once you write it as a condition precedent to something, then if that condition precedent's not met, can't wait, the waiver of condition precedent under at least Georgia law and other law is unlikely to happen. You're going to have a massive deviation from that. So in general, I think that the notice has come much more on the stringent side now. I'm not saying there aren't exceptions to it. Probably still are exceptions to it. Depends on the facts. But in this case, I think that the acknowledgement of notice was sufficient. But as I said, if I had to do it over again, I would have given notice of the the lawsuit as well, because I think that that would have been a better belt and suspenders approach to doing.
Well, you might have resulted in a negotiated outcome instead of the litigated one.
Yeah, and that's the interesting thing about this is that we spent our entire time trying to get to a negotiated outcome because we understood that it was an uphill battle, and we actually recovered more than we expected. So, you know, we knew we were going to get the interior panel. I mean, we had them on the interior panel because that's Walmart's property. That shouldn't even be in debate.
Right.
I think they made a big mistake not paying for the interior panel. So we were hoping they'd pay for the interior panel and pay something else towards general conditions and maybe something towards engineering. But we knew it was a long shot. We came a lot closer actually on the above ground wiring. And like I said, in light of the rip tear arguments today, that would be a different argument today.
What were the legal expenses for each side to resolve this? How much was the cost of the claim versus the legal expenses to go through it?
Well, this is going to shock you on that, but it has to do with the way in which we handled it. Keep in mind how this thing went, right? So I wrote the letter, right? I drafted a lawsuit that was a default judgment against a subcontractor, and then I garnished and had a hour and a half hearing on the garnishment. So the legal fees all in were $8,000, I think, way beyond or way lower than what you would have expected. So net, you know, nobody got attorney's fees on either side. So unfortunately, that's the system. You know, do you want to go down that road or not?
Sure.
But there's a net return that wouldn't have been possible because the sub was DOA. So there was no money coming out of the sub.
Yes. What do you think about having provisions for legal fees in your contracts?
Prevailing
I think you absolutely have to have prevailing party attorney's fees in your contract. You won't get recovery of attorney's fees if you don't have prevailing. We arbitrate all the time. I can tell you, we know the arbitrators that are out there. They will tell you in the absence of that provision, they're not going to award attorney's fees no matter what your theory is.
That's the first thing that goes in the mediation or arbitration.
Although I'd be careful about the prevailing part. Make sure you don't say substantially prevailing, because I've had that issue too. Because that gets into defining what substantially prevailing means. Prevailing is easier.
And you're going to litigate that.
And even prevailing,
You might win and lose. You might win and lose at the same time. So.
and even prevailing ends up being litigated as to whether you prevailed on the majority of the issues, the majority of the money, and you know, all over the place.
But substantially prevailing makes that far worse.
Yeah.
Well, if you, as a contractor, if you drafted the document, doesn't the non-drafting party get to interpret it?
It depends on whether you put the provision at the end of the contract that says that this is jointly drafted or not, which we put in all our contracts.
Okay.
But to be fair, I've heard this argument. It doesn't fly at all in arbitration. They know better than that. And I've never seen a judge that, you know, I mean, unless you're really talking about an imbalance of power between the negotiating parties on who's drafting the contract, that provision rarely carries the day. It gets argued a lot, but it's rarely the reason.
I guess this is a loaded question a little bit, but based on our experience that we've been through here lately, it seems to me, you and I talked about this earlier, regardless of notice, regardless of whatever steps you take, 9 times out of 10, it's a denial of coverage. Is that accurate? I mean, that's in my little experience.
Yeah.
It's denial, and you're going to start the steps that we started, and they offer you some menial sum.
Depends on the fact patterns you're encountering. In your case of your fact patterns, that would be an accurate statement. But in general, what I see,
Lucky you.
I don't make the facts. We've also overcome that, I might add, in a majority of those. But it's much more common that they're just simply going to defend under a reservation of rights, and that is a temptation to believe that you've actually got something when you might not, because defending under a reservation of rights does not mean they're going to indemnify for anything. So it means they're going to defend, and if somebody gets stuck holding the bag at the end and they don't indemnify at that point, they're going to be just fine with that, because the law is very harsh to carriers who deny coverage. It is not harsh if they defend under a reservation of rights, because the duty to defend is viewed as a much greater obligation than the duty to indemnify. So it's much more common that they will indemnify. But if you find yourself in a circumstance where the fact pattern is that you already are to the point where you've had to expend those funds, and so essentially you're already to the point of where you have to get to indemnification, then the likelihood of denial is going to be greater.
And I would just say it's definitely perspective on that point, because I mean, the vast majority of the general liability claims that we're involved in are not litigated at all. I mean, they're investigated, they're paid, they're acknowledged and paid by the carrier, and we have lots of those. But the ones that you guys connect with these guys on, they tend to be controverted, facts and circumstances.
Well, and we've also had an unusual policy, which I don't know how many general contractors are in the room, and you may not have this policy, but we've litigated the policy for construction management services and what that covers. And that is a very different policy than CGL. But if you get a construction management policy, you get into a different level of argument. And the reality is that the AIA contracts combine construction management services and general contracting services into the same document. They are different services, and the impact of them are different. And so we've prevailed where we wouldn't have prevailed on trying to make a CGL claim because it wouldn't have been covered by general contracting services. We've actually prevailed and gotten recovery on construction management services because it was design issues and those kinds of things. So there
can be very broad coverage in those policies.
It can be, but that gets into, kind of evaluating your risk on the front end. And then, we tend to be pretty actively involved with our clients as the project is being administered. We don't just get called in, when guns are drawn. So it's generally much earlier than that.
I think sorry.
Go ahead.
Got something, Chad?
Well, I was just going to say, when we were talking about notice requirements too, also thinking about who you're notifying and making sure you're covering all the available sources of recovery and insurance policies. I think it's real easy in this situation to think, we got to notify the subs insurer. You also got to think about your insurer, and if there was something where the owner was involved or there was a design error, making sure you're passing that upstream too. And those all have to go out at the same time. It's not I'll notify the sub and then, I thought about it. Now I've got, the engineer or somebody else that I've got to notify.
I mean, beyond that, even, our normal protocol is if we're helping, assisting with a claim that's a downstream, caused by a sub, but we ensure the general is exactly to your point. We make sure that the client makes sure their counsel puts the, notice to the sub, but then we'll notify the GL carrier and or the excess carrier. We had a incident recently that was sort of a exceptional case where we had a general liability claim that was reserved at a relatively modest amount of money relative to the limit that was in play. So it's, $1 million limit. It's carried at like $200,000. Unfortunately, there was a non-standard excess carrier that had an endorsement, policy language that said, you got to notify us of everything. And we got into a battle with them over what constituted notice. I mean, they got lost runs from us for years showing this claim, but yeah, it's even, it's an even bigger morass than you would think, because there's non-standard language, above, on the upper limit. And this claim ended up blowing up and becoming, gigantic. Yeah. And lots of parties involved. So yeah.
But who
notices are, they don't hurt you in my mind. In most cases, some people will argue certain insureds will argue that point, but most of the time on the construction side, we would err to notice everybody under the sun and not, if it never becomes anything, it's just a note in a report.
But if it's a subcontractor's policy and it's non-standard language, the general contractor doesn't have that policy typically to even know there's non-standard requirements.
Well, and that obligation would not fall to you. That would be on his side. If you notify them, whether he his agent notifies that excess carrier or not, that's not your problem.
But then he becomes self-insured. If it's denied to him, it does trickle up to be my problem. Sounds like.
Well,
it could be, but
could be.
your ability, it might be easier to recover out of your own insurance than out of the subs, even though there's a premium associated with it.
But it might be a better protocol to say if there's an umbrella, if there's a concern at all that this was a severe bodily injury case. So there was potential for, if it's a property, but if you're concerned about limit and you've got access to an umbrella limit, which goes to the point we were talking about earlier, whether you've even required that or not,
Right.
It probably wouldn't hurt to formally state you need to put your general liability carrier on notice and your umbrella
And
carrier on
CC
notice.
them all in the letter.
Yes.
Like how.
So you notify
here.
Yeah.
Okay, but I noticed it was notarized, or it was a certified letter to the sub, but not to the insurance carrier. On the CC? Do you?
I think we did actually send
I
it
think we sent it
certified.
certified.
Might not have said it, but we did send it to them. We had proof that they got it.
Okay.
They took it seriously because they responded to it.
So like if you had a fatality that was caused by a sub or something, I think you want to go to the extra level of diligence on that. Well, we appreciate you coming out. This is our last program of the year. And we appreciate everybody making their way here. We've got a number of programs scheduled for next year. If you got notice of this other than an email invitation from Katie for some reason, please let us know afterwards and we'll get you on our primary invite list. Also, when you see programs, invitations come to you and it's not something appropriate for you, but you want to send a team member, that's always cool. We don't discriminate against that, so please do. Our first program of next year is an economic outlook and look back, and it's a little bit of a special deal. It's on January 9th at Atlanta Country Club, so watch for those invitations. And then our second program, we've actually got two programs in January. The second one will be a lunch here, January 15th. Topic of that is strategic recapitalizations. And we'll have a speaker, Chuck Armstrong of West Highland Capital. One of the trends that, just is a natural evolution of the business community is that, there's a lot of baby boomers that are transitioning ownership. So we've done a number of programs on, selling your business, ESOPing your business, recapitalizing your business. And this is kind of in that general theme. So if that's something that you see coming down the pike, we'd love to see you there. Thanks to Kevin, Tony, and Chad today. This was a great program. I think it really gets behind the curtain of some of the nuances of this stuff. I'd like to also thank Katie Kamahiva for putting all this together. Without her, we wouldn't be able to do this. Thanks very much. Thank you. That was great. Thanks very much. Appreciate it.